On the 14th of January 2026, news sources were reporting about a new State Department policy that would be effective starting January 21st of 2026 that would suspend issuance of immigrant visas to applicants from 75 countries. The countries covered a wide array of size and locality, ranging from Russia, Kazakhstan to smaller Caribbean islands such as St. Kitts and other smaller countries. The impact, though, will be quite widespread, at least during the full extent of this suspension of visas. No deadline was issued as to how long the suspension will last for, and ostensibly it was implemented because these countries, or the applicants from these countries, tended to have a higher risk of being what's called public charges. Public charge in immigration law refers to people who receive or take advantage of public benefits, socialized programs, and other taxpayer-supported programs that supposedly would come at the expense of American citizens. And so supposedly applicants from these countries were at a higher risk of filing for public benefits, and therefore, until a new program was worked out whereby they could better analyze and screen applicants from these countries, suspension of immigrant visas for all applicants from these countries was temporarily suspended. It seems quite obvious that selection of the countries that fell in this so-called blacklist was driven in large part by political considerations, since I think it's hard to argue that more applicants, say, from Russia or Brazil, were more necessarily likely to take advantage of public services in the U.S. than, say, applicants from China or India, neither of the latter of which were included in this list. So it seems somewhat arbitrary as to who was included in the list and who was not. Now, the bigger question is, what are the consequences of it, and what are the possible ways around this temporary suspension? So again, it's a suspension of the issuance of visas, and only immigrant visas. So if you're looking at filing for an E2, an L1, H1B, or O1, this directive should have no effect on you. But if you're looking at, say, an EB1A, EB1C, or let's say a family reunification green card, then you would be affected by this if your nationality is one of the 75 countries in this list. I should also note that this new decree does not affect other typical non-immigrant visas, such as student visas and tourist visas, etc. And therein lies a good loophole that could help people moving forward, but we'll get to that in a moment. Besides the fact that this applies only to immigrant visas, there's one other crucial component of this. That is the fact that this applies to the issuance of visas, meaning this affects people who are going to any U.S. consulates overseas to acquire an immigrant visa. The Constitution grants the president very broad authority in terms of regulating who and how applicants at the embassies are processed and what requirements they need to meet in order to acquire their visa. What's important about this is it does not apply to cases of applicants who are in the U.S. and filing for adjustment of status. So to remind you again how the U.S. system is set up, visas are under the purview of the State Department. Status, or anything involving applicants within the U.S., is handled solely by USCIS. So it's important to note that this new instruction only affects people outside the U.S. who are applying for an immigrant visa at a consulate. In some respects, this is very similar to the new H-1B rule that Trump implemented last year, imposing a $100,000 surtax on any new H-1B visas. And similar to that situation, that $100,000 surtax is only applicable for visas issued at a consulate. Whereas if the person is already in the U.S., has some other status, and is changing status or adjusting it, that $100,000 surcharge for H-1Bs would not apply. Similarly, in this new policy about immigrant visas, if an applicant is able to come to the U.S. with some other visa, could be a tourist visa, student visa, maybe an L1, maybe an E2, he or she could then file for an adjustment of status and acquire their green card here in the US. And that would obviate the necessity of going to an interview at the consulate. The person would not have to leave the US. They could do all the processing for the green card within the US. And in that case, this new decree or executive act order would not at all apply to those people. So even though this is a rather draconian measure by the administration and it's most likely to be challenged in court, court cases take time, 6 months, 12 months, possibly even longer. And so we're trying to provide our clients with actionable strategy and information that they can use right now. And our best advice that we can provide at this point is do your best if you are outside the US and not currently here, do your best to acquire a non-immigrant visa. Could be something as simple as a tourist visa, could be an E2, L1. And if you and your family are able to get that non-immigrant visa, come to the US, here in the US, this recent executive action will have no effect on you at all, and you'd be able to acquire your green card status here within the US without any foreseeable problems. Hopefully this was of benefit to you. Please stay with us going forward as we get more details on this executive action and we provide the latest updates on how to deal with the changing landscape in immigration law in the US.